But Robert, good segue. Donald Trump is suing these platforms now to get his social media platform reinstated. The lawsuit, in a nutshell, I think he's only targeting Facebook right now. I don't think it targeted Twitter yet. Maybe I'm wrong. But bottom line, he's suing to have his social media account reinstated on an injunctive basis, alleging that they enforce these rules willy-nilly, alleging that they're effectively working in concert with government, which I like the argument on a factual basis, and that he's having his First Amendment rights violated by a private tech company. But because they're working in concert with, at the direction of, and basically in collusion with the government, they can be held to this account. And he's asking for injunctive relief to reinstate his social media platform on the basis of urgency, irreparable harm, etc. But let's get into it before I actually ask the main question. What are your feelings on the lawsuit? Any chance of success? It seems well drafted, but in law, what do you think?
So actually it relates to one of the vaccine mandate lawsuits that I didn't discuss, and also another suit we will be discussing tonight, which is you have three unique suits challenging the state actor principle. So there's a class action that's been brought against Kaiser Permanente based on their vaccine mandate, and their theory is that Kaiser is a state actor because of the degree of collusion that has taken place in the vaccine mandate context with the government. And of course, because Biden, gives dumb rocks a bad name, he keeps yipping to people about about what the government's been up to. And so more and more people are including this in their suits, saying, "Okay, this looks like state actor behavior by so-called private employers." And the other interesting thing in the Kaiser case, by the way, is they allege Kaiser is sharing people's medical information with third parties, that they're using the testing data and vaccination data and other data, and they're sharing it with other biometric and medical information and then disclosing it to third parties. So major privacy issue in that case, and I wonder whether that's happening systematically. There have been many people concerned that they would use this as a pretext to engage in massive data and information gathering that is illicit under the law. If it was a state actor, it'd be a privacy violation. And by the way, they've done this before. A case went up to the U.S. Supreme Court that relates to all three of these cases, where the government imposed a regulation that said, man, we would really like it if these particular companies would test people in a certain way. I believe it was drug and alcohol testing, as I recall. Employees sued on the grounds that that was state action. What their employer was doing was trying to comply with these regulations, that even though the regulations did not require this, it incentivized it. U.S. Supreme Court agreed. They said that's really the government trying to get away with doing things they're not supposed to do through recommended regulatory policy. And in particular, there, the government wanted the employer to share the information that they were gathering on their employees with them. Some years ago, I brought the biggest Bivens class action in American history because the IRS, which was charged with enforcing Obamacare, people probably should have paid a little more attention to that. It might not just been about getting Robert's fifth vote on Obamacare's permissibility as a tax. It was because the IRS was gathering everybody's medical data. They were using the pretext of Obamacare enforcement to demand medical the way your information gets digitally stored these days and digitally shared these days for repayment and reimbursement means there's some centralized medical records processors out there that see almost everything. They went after one of these people, and apparently they were doing it systematically across the board, and nobody just wanted to say anything about it because they thought it would embarrass them, and they didn't want to get sideways with the IRS. I represented a client who said, screw that. Now they put him under 7 years of hellacious harassment because he stood up to them. But he hired me after the harassment began. But we brought the class action because they stole 60 million medical records of 10 million Americans, including every major movie director, movie producer, movie actor, baseball player, and judge and his family or her family in the state of California. I called it Hoover's wet dream, a blackmail file. And ultimately, the government folded in that case. Folded in many ways, but that's another story for another day. But this is, I think some people, it looks like Kaiser's part of this, doing this again and again with the aid of big tech, by the way, in all of this. So they're all intertwined, but it relates to this state actor theory that is the core theory that Trump is pursuing. And my understanding is it's the same lawsuits he brought before. He's just seeking an injunction in each of them to reinstate his account.
Okay, and now just remind everybody out there who may not know, newer viewers, Bivens claim. What is it?
So when the federal government screws you, you don't have a specific law usually. We'll talk about one relating to Nazi art a little bit later, but you usually don't have a legal means to sue them. Or Nazi stolen art, but the courts recognize that creates a problem. That if the federal government violates your constitutional rights and you can't sue, how's that supposed to work? So the Supreme Court recognized in a case called Bivens versus 6 unnamed federal agents that you do in fact have an implied right to sue for a violation of certain constitutional rights. The courts have played games with which ones you get to sue on, but the Fourth Amendment is one of them. The First Amendment usually is. And so the question is, in this state actor context, to what degree I don't know if they'll be able, I think trying to prove Kaiser Permanente as a state actor is going to be uphill. But again, the Biden administration's helping their case a lot by yipping about how he's.
They can be deemed to be state actors on a punctual basis, on an issue, on a specific issue basis. So not at large, but at the very least here, yes. So I mean, I don't know what the threshold is. I know what criteria is because the lawsuits all allege the criteria, but it's just a question of whether or not the judges say it has met the threshold. So Trump now is coming in and saying, reinstate my Facebook accounts because you're violating my constitutional rights in this particular context. Given the new facts coming out of Psaki, they're acting at the direction of, coercion of, or there was another word that started with C, the direction of the state, and therefore they're subject to constitutional requirements or restrictions, and they should have to reinstate my social media accounts. My issue, Robert, is it's an injunction. You have the balance of the inconvenient, irreparable harm, urgency, color of right criteria. It's been now 9 months since they've cut him off social media. How do you come in 9 months later and say, now I want to come back? Are you not now going to be blocked by not the theory of the clean hands, but latches? Like, you waited too long. Obviously, there's no urgency.
I think that what I'll give him credit for is the briefing is much better than the original complaint was. Yeah. And what they're actually doing is they're borrowing from a Yale law professor who several years ago wrote. I work with him in another case. I know him, but it was a very smart article, and his argument was this. He went through the whole history of state actors, and his argument was that when you combine some means of coercion, some means of public pressure, is the way he put it, a pressure campaign plus immunity equals state actors. And so his position is, and this, like the way in which that case I was talking about earlier, the Supreme Court said it's clearly state actor. They said it wasn't just the fact that you put pressure on them through this incentivized regulations. You gave them immunity if they went ahead with it from suit. And they said that you combine pressure and immunity, then you got a state actor. You got someone who's really doing something because the government suggested they do it and incentivize them to do it. And so the argument here is Section 230 acts as a carrot, and the pressure of antitrust or other claims or regulatory or legislative hostility acts as the stick. And because Democrats can't keep their mouths shut, because so many of them have been very aggressive in their language, I mean, to the point where Congressman Schiff and Senator Warren are out there threatening Amazon not to publish books they don't like. I mean that it's like, come on. I mean, that was actually another Supreme Court case where the Rhode Island Commission that had no punitive power told people, we would rather you not have these books in your local bookstore. The Bantam Books case went up to the U.S. Supreme Court. They said that was state action. So now the counterpoints to it is there's another case where it was not fully that degree of pressure and no immunity. And the Supreme Court said, no, that's not state actors. So depending on which court you're in and depending on which precedent they follow, you get a divergence. But there is case law out there that says pressure plus immunity equals state actors. And they're getting more and more evidence of that for Trump. Now, I think the hard part he's going to have is they're going to move to transfer the venue before they already have, before on venue choice issues, before they'll ever hear this. And he'll be stuck in California. I agree. I think he has an uphill battle. I don't think the complaint was as well crafted as it needed to be. I think that put him a little bit behind the 8 ball. This is a better briefed version, but he really should have the best lawyers involved. He has some decent ones, but they're people that are borrowing from other people. He should have those people involved, ideally.
Was this motion drafted by the same firm that drafted the initial lawsuit?
Yeah, but with some additional lawyers, but not the ones that have known experience in this. But they clearly read through some of the material that some of the rest of us have put together before.
And
And so they copied and pasted it kind of. I mean, they did a good job. I mean,
it reads well. It reads well. It just, in my mind, should have been done within a month, not within a year of him being deplatformed. Some people in the chat are saying, it's not about winning. It's about getting the story out there, and let them come down with a judgment that says, I think that my prediction is they're going to avoid the substantive discussion as to whether or not they are state actors on this particular issue or question. They're just going to say you waited too long, so clearly there's no urgency. You don't satisfy the criteria for an injunction. Move to the permanence where you don't have to provide, where you don't have to prove urgency. We'll see, but it's a compelling read. It's good, and it's just putting those facts out there for anybody who's paying attention, that there's quite clearly, if it's not collusion, it's collaboration between the feds and big tech, and there's direction, there's back channels, there's all sorts of things that you probably won't know about if all you read is New York Times or CNN, but it's there and it's real and it's meaningful. The only question is any court going to stand up and say enough is enough, or call it for what it is?
I mean, I think one of these cases in the state actor context, whether it's the Kaiser Permanente case, the Trump social media cases, or the Dershowitz Dominion cases, one of them is going to go up to the Supreme Court because they need to provide clarity about this. Because what's happening is politicians are using what they perceive to be loopholes to pressure with legislative threats, get people into following a certain policy that they wouldn't instinctively. Because my guess is discovery, and this is one of my issues with the Trump complaints, I would have just alleged these things upon information and belief so that you can get past a motion to dismiss into discovery. My guess is that there's going to be internal communications at all these social media giants 100%. Where they were in fact responding to the threats.
There's back channels. It's just a question of people are going to say they're going to delete the emails, wipe the hard drives. There's no question, because you don't come out and make public statements like Psaki makes, like other politicians make, talking about back channels without there being some correspondence. It'll probably not read in the sense of like outright conspiracy. It'll just be like, hey, can we talk about what we talked about? How do we address what we talked about? But there's no question there's going to be stuff to discover, and it's going to be beautiful.
Well, then you have plenty of Maxine Waters kind of statements. They should have probably included more of these kind of statements, but congressmen who said things like Facebook better get the message about this misinformation or they're going to see the consequences. That kind of language. That sounds like coercive pressure to me.
No, that sounds like that's what they say publicly. You know damn well they're saying stuff privately